Now, Mr. Gratian, you're taking us through the history.
Yes.
At some point, we'd like your submissions on when you say the relevant date was, in other words, the alleged date of wrongful retention.
Certainly.
And what the judge found about that.
Is it most helpful if I deal with that now, or
Why not?
take it in turn?
But we still think you should go through
Yes.
documents as brief as you can, but nonetheless, that's the question we'd like your help with first of all, please.
My Lord, in relation to the dates of retention, there were probably, on the basis of the evidence, and I won't trawl through that for the purposes of this argument, a number of possibilities, but the simplest formulation was that which the judge in my submission adopted, which was that the child came here in September 2020 for what was intended to be a week's holiday, that holiday was then extended by discussions between the parties to December 2020, January 2021, and that there was then a further extension
Because of COVID.
Because of COVID, the mother having told the father that the schools in England were open, whereas the schools in Germany were closed until July 2021. So, my Lord, that is, I describe that as the simplest formulation because A, consent was given. The end point of that consent was, on the father's case, July 2021. The judge considered the evidence in relation to the parties' agreements, mainly in relation to, or on the basis of, WhatsApp messages that they had exchanged, and found that that reflected the discussions they had had and the agreements that they had reached.
With what result as to the question of relevant date?
The relevant date being July 2021, which is based on two parts of the papers that we have. The first being the judgment at paragraph 61 and 62, which is the core bundle, page 57.
'60 and 61.
61 and 62. Broadly, 61 deals with the period September to December, January, and 62 deals with the subsequent extension January to July.
It's funny, it doesn't actually say July. She never actually says it
Well,
came to an end on a particular date.
My Lord, I appreciate that, but in the order that Mrs
Right.
Justice Theis made, she does specify July.
Okay.
So the order is within the same bundle at page 37. It starts at page 36, but the relevant part is page 37. Recital 1.
Yes, July 2021.
Right. And right. And her determination was the child was habitually resident in Germany.
Yes.
Okay. Right. That's very helpful.
Was that based on particular WhatsApp message? I mean, where does July come from? Was it oral evidence, or was it?
As is often the case in cases of this type, these two parents exchanged hundreds of WhatsApp messages about various different things. But within those messages, there is clear reference from the father in relation to the extension in September, that was limited until Christmas.
Yep.
And the mother was responding to him essentially saying, and this is, if we go back to the judgment, this is where the judge at paragraph 61 draws the quote process in italics. The mother was saying she wanted the child to stay with her while her process was continued.
That was her asylum application.
Exactly,
Yep.
the asylum.
Yep.
The father's focus thereafter, having agreed to the extension, was the child being back in Germany in sufficient time to prepare for and to attend school, which he was due to begin at the end of the summer of 2021, and that is where July comes from.
Okay.
Where does she determine what the habitual residence was as at that date?
Well, when the judge reaches her conclusion about habitual residence, forgive me while I find
Previous paragraph.
in the previous paragraph, she says that the child was in September 2020 habitually resident in Germany and remains so, and remained so. So it's the penultimate line of paragraph 60.
But that's pretty unclear, isn't it, what that means? Because she then turns to the circumstances coming to this jurisdiction. And then she moves on to the question of consent.
Yes.
Effectively.
Well, my lord, that's, in my submission, the import of how the case was put to her. She was, in effect, asked to determine, on the basis of the mother's challenge to this, whether the child had, by September 2020, acquired habitual residence in Germany. That was the live issue that really everything that happened at the final hearing was directed to. But in any Hague Convention case, in order for a removal or retention to be wrongful, habitual residence must be in the country that the child was removed from or retained away from at the time of the retention. If it wasn't, there is no wrongful act and no return order can be made. And the judge plainly knew the terms of the Hague Convention, she knew what she was dealing with, and concluded that the retention, which she found happened in July 2021, was wrongful. And so she must have made a finding.
Her finding at the end of 60 is, although there is limited evidence of significant integration in the wider community, I'm satisfied there was some integration.
In Germany.
Ex's habitual residence was in Germany and remains so. But so she's, as it were, there was some integration there. But the whole analysis, it seems to me, begs the question of what impact does the fact that the child was then resident with the mother and going to school in the United Kingdom for the entirety of the following school year, have on that slightly tentative conclusion? And that seems to me not to be a question which isn't addressed at all.
Mr. Gratian, there is, it seems to me, a difficulty here, which my lord is alluding to, which is that as structured in the judgment, I think that's what we're saying, as structured in the judgment, it looks as though the relevant date is September 2020, because the judge then, she says, subject to any defences, and she then considers what happened after September 20 in the context of the defence of consent.
Yes.
And she decides there wasn't any consent, so the defence wasn't made out. But in her, as you rightly pointed out, in the recital, the date is given as July 2021. And that required the events of September 2020 to July 2021 to be assessed with regard to establishing whether or not habitual residence had continued. She said it had, but she didn't consider what had happened in terms of integration, etc., in England in the intervening period.
Neither party suggested to this judge that September 2020 was the date of any wrongful act. It wasn't alleged by anyone that September 2020 was either a wrongful removal on the basis that the mother had procured the father's consent by deceit, which would be, and there was some discussion about this morning, a vitiated consent for the purposes of Article 13A, and could lead to a conclusion that the mother had wrongfully removed the child, effectively, or certainly immediately wrongfully retained the child then. The mother never advanced a factual case that upon the child coming to England, she never intended to return him to either the care of his father or to Germany. That simply wasn't part of the case that she ran.
So the way it was argued by the mother was never habitually resident in Germany. That was fair. But when the period September 20 to July 2021 was, the mother's case was, I was always going to send him back.
Well, my lord, this is, in a sense, part of the difficulty of the way the mother's case was advanced. The WhatsApp messages show, as the judge found, that the father was, in the period really from October 2020 through to December, saying, we had an agreement that child would be with you for this period and then he would come back to me in January. Within those messages, the mother never said to him that she wasn't going to send the child back to Germany. Her responses to him were really, to summarise, couched in terms, I need him here for my process. So she wasn't saying, I am not going to return this child. And then, as the judge found, after January, there was an agreement to an extension of the period of time for which the child was going to be here. In terms of how she put that case before the court, and, my lord, it's sort of helpful here to dovetail into the documents again to see how this progressed.
Well, I want to do that, yeah.
But in terms of how she put the case before the court, her case was that he never acquired habitual residence in Germany, but if the judge found that he did, she relied on consent. So the way the judge deals with it in these paragraphs of the judgment, in fact, in my submission, directly flows from the way the mother formally pleaded her case. So would it be helpful to go to that?
Just to say that the process by which the child remained in this country was effectively the exact mirror of the way that he remained in Germany, isn't it?
Yes.
And surely anyone analysing that in terms of whether that gave rise to habitual residence would necessarily appreciate that the same question arose as regards the period from September to July 2021. It's not really a matter of great analytical complexity to see that that issue arose on these facts. And if you're going to show us lots of documents that show that actually was never the way the case was put, then I think that's accepted. But
Well,
I'm not stopping you.
Was there information in the statements, the mother's statements, that which indicated a degree of integration?
In my submission, my lord, no.
I think I would find it helpful to see what her formal pleading was. At the moment, my understanding is her case, as you've said, is that child never acquired habitual residence in Germany, but if he did, then there was consent to him remaining in England, with, I think, two consequences. One, the retention was not wrongful, and secondly, he had become habitually resident in England, and that second part was rather put forward sort of watching, but it follows, doesn't it? If the consent is to move to England permanently, then it does become habitually resident. And the problem is, the judge found that the father didn't give consent to a permanent move, but did give consent to a move which, on the facts, lasted from September 2020 to July 2021.
Yes. Well, there is... Every case where there's a determination of habitual residence is a question of fact. And
yes.
So what I'm about to say isn't intended to water down that basic proposition, but as a generalisation, where a child moves with the full consent of both parents for a move that's intended to be permanent, that may give rise to, depending on the other facts of the child's life, a different conclusion as to their habitual residence, as where a child has moved with the consent of only one parent, the other parent having been misled, for a period that is time limited. So it doesn't follow as a matter of course that because there was a limited consent here, different of course to what the mother pleaded and asserted as a matter of fact, a change of habitual residence would have followed.
Just a moment. So it doesn't follow from the fact there was a limited consent to a period here of 10 months that there was a change of habitual residence?
No, not automatically, without there being more. Just because this was raised with me by Miss Papazian just when we broke for lunch, and I didn't mention it earlier, there is one more reference in the mother's statement that I took some of you, but probably not all of you, to before lunch, because we couldn't find it in the bundle, to habitual residence. Which is, and I think where I have it now, and I hope everyone can find it, is page 51 of the appellant's supplementary bundle, paragraph 21.
But I don't have the appellant's supplementary bundle.
Well,
What does it say?
it says that it's only 2 lines. So paragraph 21 of that statement says, the child has resided in the UK now for over 15 months and is habitually resident in the UK. Therefore, I ask the UK courts to deal with the case here.
Right.
So as
That's
a matter
quite a clear. That is quite a clear assertion, isn't it?
well, it's an
That was in
assertion.
her statement of.
23 December. It's an assertion as to the situation at that point in time, not as to the question that the judge is actually engaged in answering.
Right.
And it is a bare assertion rather than a matter of evidence that would allow the court to weigh up competing factors as to where the child might be habitually resident and reach a determination.
Going back to the point you made previously.
Yes.
Yes, it's right. I mean, obviously, the longer a child is present in the country, the greater the likelihood of the degree of integration being required. And 10 months is not is one would expect long enough, as a sort of rule of thumb. But it doesn't. You see your point. It doesn't necessarily follow
No.
that a limited period, consensual period, would lead to a change of habitual residence. Well, never mind. We think of examples of boarding schools, etc., or whatever.
Yes.
But this wasn't explored in the case at all.
No. But the reason, and this is to come back to, I keep saying I'm going to do this and then being distracted.
No. Well, I know. We're not helping.
But to come back to the point that arises from the documents, if we look,
Right. So
I have this in the same supplementary bundle, which it turns out not all of you have, for which I apologise. But
What is it?
on the 17th of February, the first involvement that Mrs Justice Theis had in this case, she recorded on the face of the order, and this is...
We've got that.
I'm
In
great.
this bundle, the one with the crossings out, it's 43.
Yes. So she included on the face of that order recitals about what the mother's case was stated to be. Paragraph 1. The child was wrongfully retained in Germany in May 2019 and remained habitually resident in Uganda until September 2020, when the father brought him to the UK and on the mother's case agreed to him remaining. Accepts the father has rights of custody and then asserts or confirms she's continuing to defend on the basis of 13A and 13B.
Okay, so her case was he never acquired habitual residence in Germany.
Yes. It was within that order that Mrs Justice Theis required the mother, as she should have done previously, to file an answer.
Right, so just a moment. So page... This is the respondent supplementary. No, this is the respondent supplementary bundle. Page 43, order of the 17th of February. Theis J. Recording mother's case.
Yes.
Wrongful retention in Germany, May 2019. Therefore, habitually resident in Uganda till September 2020. Okay. Yes?
The answer was filed on the 25th of February. Again, I have this in the appellant's supplementary bundle. It seems not to be in the respondent's supplementary bundle, and it isn't in the core bundle. It's electronic page 232.
All right, well, I think I'm going to try and find this. Bear with me just a moment.
I have a download link for it here. And
Yeah,
can
it didn't work
forward
for me,
that.
that, unfortunately.
I don't think I have the appellant's supplemental bundle.
I think it might be the one that my lord was looking at the mother's statement
Oh, right.
in when we were having difficulties with that before lunch.
What page is it in that?
The answer in that is page 232.
Okay. A statement to the mother,
Yes, that's what it's titled.
25,
Yes.
1st of February.
Well, this isn't, I'm afraid, where I'm thinking I'm going to find this easily.
I mean, this is less than ideal, but worst comes
No,
to
it's-
the worst. I can access it on my iPad and hand it up.
Yes, I found it.
I'm grateful.
Where did you find it? In an email?
Yeah, the email, it was sent to me and to you by my clerk on Wednesday the 7th at 15:16.
Got it. That's a link. That's the link I tried to get earlier. Got it. Excellent. What page?
232 is the first page.
Sorry, Christopher, to be so slow.
All right.
Okay. 232.
Just because it's headed as a statement.
No, that's not.
Can
that-
see from paragraph 2 that it's the
no,
answer.
I'm not in the. I'm sorry. That isn't the right. That isn't the right page. I'm looking at the supplementary button. What's it called? We're looking at the answer. Is it?
It's termed as a statement of Mother 250222.
Fifth statement of the respondent.
Okay, that's because the pages are numbered differently. It's 233.
So paragraph 2 shows this to be the answer that Mrs Justice Theis directed. In relation to the mother's case on habitual residence, paragraph 11, she doesn't accept that the child acquired habitual residence in Germany. Paragraph 15, if the court finds that the child acquired habitual residence in Germany, the two defences which I'd seek to rely on are 13A, consent acquiescence, and 13B.
What is the date that the respondent had, your client, the father, had asserted to be the date?
July 2021. And there is, I can't remember.
He said that in his originating application, did he?
He said that in the originating application, and there is reference somewhere, and I'm afraid I can't now remember exactly where. It might be within Miss Jones's skeleton, to the father having confirmed at the hearing in December that that was the date that he was relying upon.
there's the assertion in paragraph 22 onwards, albeit I think in a different context, that he's integrated within this jurisdiction.
Yes.
He's been in the UK since September, attends school, made friends in the community, settled in my care, attends Bright Kids, etc. I mean, all of that, although I do appreciate it's been, I think it's been put forward as part of the 13B argument.
Well, it is.
Nevertheless, that all screams habitual residence, doesn't it? To any experienced judge.
My Lord, it's... In my submission, it might. However, it is rather more, in my submission, bearing in mind the context in which it's raised, part of what would be termed as a quasi-settlement defence under Article 13B, which essentially is, I think, part of the point that is made under grounds 7 and 8, that this was a child who had been here for so long.
There seems to be as much evidence. This is as much evidence of habitual residence in this country as there was with regards to his habitual residence in Germany.
My Lord, I think the judge commented on the paucity of evidence either way.
Yes. When the judge realised that she had to decide on habitual residence as of July 21, and that was at least put forward in some parts of the mother's case, albeit not emphasised in closing, presumably she would have had in mind that this evidence as regards what the position was in this country on that day.
Well, I think, my Lord, it's quite difficult for the judge. She has, as I've said, I think about 500 pages of evidence. The references to particular evidence about habitual residence we've narrowed down, I think, now to 2 paragraphs, one in an answer in the context of the Article 13B defence, and one in her statement. The only reference to a change in habitual residence from Germany to England that is pleaded is 1 paragraph in Miss Jones's skeleton, that as far as can be seen, and certainly on what I'm told by Miss Papazian, wasn't then pursued during the course of the hearing at all, and it doesn't appear in the closing arguments.
There's the skeleton and the position statement.
There was just the skeleton, my Lord, I think.
There was a position statement and a skeleton and closing submission.
You saw the position statement. Oh, sorry, maybe you didn't see it, but certainly you were sent the position statement.
There are 2 documents on it,
Okay, my Lord,
and they both refer to it.
I have what I was referring to, and I apologise if I've missed something, is the document dated the 22nd of March at paragraph 25. That's the one that I have. If there was another one that said the same thing on a different date, then so be it, but I haven't seen that one.
Okay, going back to the answer, 2
Yes.
points. First of all, the passage to which my lords referred, in which there is a reference to integration, paragraph 22, looks to me as though it comes under the passage where the judge is dealing with the 13B defence.
Yes.
Paragraph 21 says that, 22 comes after that, and it leads into 23 and then 24. So that's when that's when that's raised. But it is there, as my lord says. Where paragraph 20 confirms that your client's case is July 2021 as a date. I'm very confused by this date, as the applicant agreed for H to live with me in the UK, but did not like the fact I issue private law proceedings, etc. Did not like no, there's a comma there that shouldn't be there. Did not like the fact I had issued private law proceedings to confirm this in writing, and therefore alleged I had wrongfully retained H, which I deny.
Yeah.
He consented to H living with me in the UK from September 2020.
Yeah. Well, that was the mother's case, but the judge rejected that.
Well, where did she expressly reject? Oh, she rejected the consent case, yes.
Yes. I'm sorry, my lord. Perhaps I'm missing something
No,
in
no,
this paragraph.
the truth is, Mr. Gratian, I think we're all trying to put a pint in a quarter to a... No, that's wrong. We're trying to fit something in which doesn't fit, aren't we?
Something that doesn't fit easily. Well, certainly.
Yeah, okay. Now you're going to take us to the documents.
But just before you do that, can I ask you about paragraph 19? One of the things that Mother says in this answer is the applicant, that's father, agreed that this court, UK court, had jurisdiction to deal with the proceedings and that H was habitually resident in the UK. What is the effect of issuing the Children Act proceedings in the UK and the father's submission to the jurisdiction? Is it right that there's implicit in that an acceptance?
Depends, doesn't it?
It does depend. Well, what happened in the private law proceedings was that the father attended the first hearing of that in person, and a question was raised as to jurisdiction, which I think it's fair to describe it in this way. It appeared he was accepting or not challenging, and he was required by the judge to put in writing his acceptance.
Yeah.
There was then a document produced by him, which I don't think that I've seen, but which appeared to accept jurisdiction. However, he then sought to take legal advice, and upon doing so, he commenced these proceedings. There is authority in a case called Riar that suggests that where a case comes before a court and it appears that there might have been a wrongful removal or retention, there is an obligation on the judge to make known that fact.
Freeze it.
Well, firstly, and that's a second stage
Okay.
almost, but the obligation first on the judge is to make the parties, particularly if one is a litigant in person, aware that there may have been a wrongful act and to invite them to take the Hague Convention remedy if that's what they want to do. When they take that remedy, then because of a combination of Article 16 of the 1980 Hague Convention and Rule 12.52 of the Family Procedure Rules, the domestic proceedings are stayed. And when the father commenced these proceedings, that is what happened to
So
the
they're still stayed, are they?
Yes, they're still stayed.
Yes. My question was a slightly different one. Was that by bringing the private law proceedings, was the mother implicitly or expressly asserting that the jurisdiction of the court was engaged because H was resident here?
Yes.
And is she right, therefore, to say that if you accept that, you're accepting that H was habitually resident here?
No,
No.
not necessarily.
Not necessarily. What is the jurisdiction of the family court sitting in private law proceedings based on?
Either habitual residence,
Yes.
or it can be, in certain circumstances, based on presence.
Well, H was undoubtedly present here.
Yes. It may be that if a person, and I'm going to add to this, fully informed as to their rights, so if the father had been aware of the possibility of a Hague Convention remedy, had then consented to the continuing exercise by the English court of a jurisdiction, that would have a consequence on Hague Convention proceedings.
Yes, I see.
It might suggest that he accepted that the child was habitually resident here. It might alternatively be acquiescence for the purposes of Article 13A. The key factor here in my submission is that he was in person. As soon as he
once he took advice, he brought the Hague proceedings.
Precisely. So it doesn't suggest of a fully informed acceptance of what was happening.
No, but does it suggest that the mother's case in the private law proceedings was that H was habitually resident here?
Yes, as a foundation of jurisdiction. But there are various... I mentioned earlier at the beginning of my submissions in a different context, Article 7 of the 1996 Hague Convention. Under that article, it's entirely possible for a child to be habitually resident in England, for example, but the English court to be unable to exercise jurisdiction because pursuant to Article 7, that jurisdiction is retained somewhere else. There are other possible consequences that flow from the issuing of private law proceedings, albeit this becomes probably unnecessarily complicated for what we're considering. But the fact that the mother issued those proceedings really suggested that she was repudiating the agreement that Mrs Justice Theis found she and the father had. A repudiation of that agreement would be or could be a retention. So the date of retention might in fact have been May rather than July. A number of possibilities flow. The main point I think that I'm being asked is, does that suggest anything about where the child in fact was habitually resident? In my submission, not. It was the mother issuing proceedings and seizing a jurisdiction, and then the father, uninformed as to his rights, accepting that they could continue, but then he changed his mind.
I understand that point. Actually, the point I was asking was a slightly different one, which was whether, by the very act of bringing proceedings, it could be said that the mother was asserting that H had become habitually resident in the UK by May.
My lord, it could. I am not sure that it would be right to say automatically that is so. Experience suggests in cases of this type that sometimes people issue private law proceedings on an entirely speculative basis in an effort to solidify the child's position here when they know it in fact to be uncertain because they've wrongfully removed them or wrongfully retained them. It is an assertion that the court has a jurisdiction, but the fact that a party asserts that a court has jurisdiction and issues proceedings based on it doesn't mean that they're right.
All right, now you're taking us through the documents swiftly. Have we got?
My lord, there wasn't, in fact, because we've already looked and in fact been back to reference to the position statement, the skeleton argument, and the closing submission. Any other documents in this regard that I wanted to take the court to?
I mean, at some point, then I think you need to address. I think we've got a clearer picture of what the confusion was.
Yeah.
But we'd like you to address the question of 2 points really. First of all, to what extent was it incumbent upon the judge to investigate matters that weren't raised expressly by the parties, but were or might have been apparent from the papers.
Yes.
For example, the issues here about the date and habitual residence on the relevant date. And secondly, how should this court approach a case where, if we are of the view that although the case was argued clearly in a certain way, the justice of the case wasn't addressed. I think I've put that in general terms, but you'll appreciate specific issues that we're troubled about.
Yes. My lord, in relation to the first of those two, we have set out in the skeleton argument some brief submissions on that point at really paragraphs 19 and 20. And the basis for those submissions is the procedural rules that we went through when I began my submissions this morning.
Yeah.
There is a particular structure that these cases follow with a formal pleading that a respondent has to enter. In those circumstances, in my submission, the court is looking at a process that is almost wholly adversarial. And in circumstances such as that, the court is required and is not required to do more than deal with the case that is put before them and resolve the issues that are raised for determination by the parties. In those circumstances, and this is why I've taken the liberty of so much time to go through some of the documents to see exactly what was put and how, the judge was entitled to resolve the case on the basis that the mother was challenging during the course of the hearing, because this really was what all of the evidence that the court heard was about, the assertion that the child became habitually resident in Germany. And in circumstances where, on her formal case, and in the great majority of her evidence, and in the closing submissions that were put to her, the judge was entitled to deal in a far more summary way the question of habitual residence thereafter, because it really wasn't put in issue before her in the course of the evidence that she heard or the closing submissions that were made.
Well, we're now clear, aren't we, that the judge, that your case was that it was the relevant date was July 21, was accepted by the judge.
Yes.
So therefore, the focus of her was where was the child habitually resident, at that date.
Yes.
And nowhere in the judgment is that expressly set out. And the point is, habitual resident is dealt with in the way that it is at paragraph 60.
Yes. And my lord, in that regard, and I appreciate that this is a small platform on which to place what is necessarily a more significant analysis, but the words "and remained so" show that the judge considered that by the relevant date the child was still habitually resident in
Well,
And remained so until when? I mean,
yes. Let's just look exactly where is paragraph 60.
paragraph 60.
Because the Lord says, well, the Lord says until when, and I add and from when, because it doesn't. She doesn't say when he became a bishop. She didn't necessarily have to say that. She doesn't say when, and she doesn't say until.
And
And the implication is clearly until at all material times.
yes.
But she then considers the defences with effect of consent with effect by reference to what happened after September. She considers the events of September onwards under the heading of consent,
Yes.
not under the heading of habitual residence.
My lord, in terms of structure, in my submission, all of that is entirely correct. It doesn't matter when the child became habitually resident in Germany, as long as the child was habitually resident there prior to September 2020. It's not material for the purposes of the determination that she's being asked to make.
But where do we find the judge addressing the question of where was the child integrated in the period September to July 2020? Beyond what she said, the limited passages in paragraph 60.
Well, we don't. Paragraph 60 is the end of her analysis in terms of habitual residence. I accept there is no separate analysis in relation to the period from September to July.
And of course, this morning I was challenging Mr. Gupta on the role of the judge in this context. We both, the Lord and I, were just drawing distinctions between this type of litigation and welfare jurisdiction and children's proceedings generally. But isn't it incumbent upon a judge to apply the well-known test of integration to the facts? And shouldn't the judge, and this is very hard on her, I know, but shouldn't she have asked herself the question, had the child acquired a degree of social integration in this country between September and July?
Well, I think I've accepted what paragraph 60 says, but paragraph 60 has to be read, in my submission, in the context of the judgment. Of course, I appreciate that probably there is no one that has stood where I am without saying this, but it has to be read in the context of the judgment as a whole, in circumstances where paragraph 48, she sets out faithfully and in full the submissions that have been made on behalf of the mother, where she has directed herself, albeit by reference to summaries, but there is so much law about habitual residence now that what can one do but rely on summaries, otherwise the judgments would be hugely lengthy. But at paragraph 37, she's directed herself to some relevant law in relation to habitual residence and the determination of habitual residence. She has plainly got it fully in mind, and she says so expressly at, forgive me while I turn this up, paragraph 57, that habitual residence can change, notwithstanding that one parent doesn't intend that it should do so, and that habitual residence can change without consent. So she's directed herself appropriately in relation, in my submission at least, in relation to the law that applies. She has set out the case that the mother placed before her. She has identified from both paragraph 62 and the order the point of retention, and in my submission must be expected to know and can be taken to know that in order to make the order she needs or is being asked to make, she has to find that there's a wrongful retention as of that date. And so whilst, as I said, I appreciate it's a small platform, from everything else she's done in the judgment, and remains so, can bear a significant amount of weight.
Where she doesn't consider the evidence, such as it was, about social integration in this country in the 10-month period.
Well, my Lord, I can only go back to what I said earlier, that the evidence, such as it was a single paragraph advanced in an answer in a separate context, and not put forward to her insofar as can be seen.
I mean, there's a difference between considering the evidence and rejecting it, and not considering it. And can you point to where she considered the evidence, any evidence about social integration in this country?
In the judgment?
Yeah.
My Lord, no.
Well, it's recognised, I think you've recognised it in the last paragraph of your skeleton.
Well, that's right.
By saying there should be, that as alternatively, a focused hearing on the issue of the date of retention and the child's habitual residence as of that date. Are you not there accepting that there has not been such a focused hearing?
I wasn't intending to, my Lord. What I was intending to do there was to put in the alternative position if my lords are against me on the appeal.
But you couldn't be suggesting that be ordered if there had been a focus on those issues.
Well, my Lord, it's necessarily conditional upon you finding against me on this point.
We all alighted on those words, Mr. Gratian,
Well,
I'm afraid.
My Lord,
As did Mr. Gupta.
Yes.
Can I ask you, I think it's really the same point, but put a slightly different way. I put several times to Mr. Gupta the proposition that in these type of proceedings, unlike welfare proceedings, the court doesn't have a sort of roving inquiry.
Yes.
Just has to deal with the issues put before the court. But the very first issue which the court has to decide is the Article 3 issue, which you accept the onus is on you, not on the defendant. The onus is on the applicant to establish that there, I think you said two things.
Rights of custody.
Firstly, that there were rights of custody, which was never in dispute, and secondly, that at whatever the date was, there was habitual residence in the requesting state. Now, one of the things that I understood Mr. Gupta to say was, whatever else the court does in these cases, it has to be satisfied of that, the Article 3 point, that there's habitual residence at the date of wrongful retention or removal. So first of all, you have to identify what that date is, which the judge, not with quite as much precision in the judgment as you might have liked, but it's there in the order, identifies the date by accepting the father's case as July 2021. Does she not then have to ask herself the question, as an Article 3, not one of the defences, not one of the issues raised by the mother, but simply as in order to embark on the analysis, was H habitually resident in July 2021? And again, you can see it in the recital to the order, but it's not actually there in the judgment in any real sense, is it?
There must obviously be a conclusion that the Article 3 case is established in order for a return to be directed. But the way in which that case is put before the court and investigated will differ depending on the circumstance. So, to take the example of rights of custody here, there was no challenge to that. So all that one has is a recital in the order that it's accepted that everyone had rights of custody at the requisite time. In some cases, habitual residence won't be challenged at all.
Yes.
Of course, in those cases, it's not necessary for the judge independently to run through the authorities and to reach a factual conclusion
Understood.
where it's not placed in issue. In other cases, habitual residence will be challenged in one way but not in another. For example, if there is a case where there is a factual question as to, this case might have been such a case, it wasn't put in this way, but if there's a case as to whether there was a wrongful removal, and if there wasn't a wrongful removal, whether there was a wrongful retention subsequently, then there might not be a challenge to habitual residence on the removal side,
Yes.
because that might be obvious. The child has only ever lived in Germany and was removed here, and so habitual residence could only ever be in one place, but it might come into play later. In this particular context, my submission is that because of the way the mother put her case, she challenged habitual residence in one way, which the judge resolved. She didn't, apart from in a very limited way and without any evidence really in support of that, challenge it in relation to the period September 2020 to July 2021. And so in those circumstances, the judge was entitled to deal with it in the very brief way that I submit she did in paragraph 60.
It is those three words, and remains so. That's the entirety of her analysis as to whether a habitual residence found in September 2020 continued until July 2021. Is that right?
Yes.
Yeah.
Can I put forward this proposition, and it's really a proposition which requires your, but everybody's help here. The first thing the judge has to look at is Article 3, as we've established.
Yes.
The 2 points under Article 3. And then, if it's established that the removal is wrongful, the Article 12 and any defence raised under Article 12 and 13.
Yes.
We always talk about the burden of proof is on the applicant in regard to Article 3 and then on the respondent in regard to Article
Yes.
13.
12 and 13.
12 and 13. I just wonder whether the judge's responsibility to investigate matters beyond how it is put by the parties might be greater when looking at the Article 3 than under Article 13. In other words, does the court have an obligation to scrutinise the circumstances beyond the way it's put by the court when considering the Article 3 questions, but less so under Article 13. After all, in Article 12 and 13, the phrase "it is established" appears, doesn't it?
Yes.
Whereas the role of Article 3 doesn't use that language.
No.
It is wrongful if it is in breach of custody and in which the child was habitually resident immediately before before the removal or retention, and at the time of removal the rights were actually being exercised. This is probably not a particularly attractive point the more I but I just wonder whether there might be an argument that because we're dealing with jurisdiction issue here under 3, the judge has to look exercising summary powers as she is, and powers which then absolve the court from any consideration of welfare. The court's under an obligation to consider the issues more broadly than put by the parties. In other words, the fact that it's leading to an abdication of the welfare jurisdiction involves the courts having a greater role than perhaps I was suggesting, perhaps rather forcefully, to Mr. Gupta this morning.
Well, I don't think that I would accept that as a general proposition. You don't have this in the authorities bundle because
You didn't know it was going to happen.
no, I didn't know it was going to happen, and also in an effort to try and keep things as manageable as possible, parts of the Hague Convention that didn't seem to be.
Which has worked so well with the papers after all.
It has, hasn't it? Article 8 of the Hague Convention sets out what, when an applicant applies, they must or should provide.
It's a long time since I looked at Article 8.
I'm sorry?
It's a long time since I looked at Article 8.
No. If I may, I'll just read
Okay.
part of it. But it says the application shall contain A, information concerning the identity of the applicant, of the child and the person alleged to have removed or retained the child. B, where available, the date of birth of the child. C, the grounds on which the applicant's claim for return of the child is based. And D, all information relating to the whereabouts of the child and the identity of the person with whom the child is presumed to be. And then it carries on by providing for documents, which I don't need to go into, which the application may be accompanied or supplemented by. So it sets out the information that an applicant is to provide, including subparagraph C, the grounds on which the application is based, which must be the law that shows that the person has rights of custody.
It's a bad, well, as you say, my point is a bad point.
My lord,
Can I put the point a slightly different way?
yes.
This is a jurisdictional threshold criteria, as my lord says. The court has its own interest in ensuring that it has jurisdiction to decide a case. In a normal Article 3 case, the court is bound to be satisfied with the Article 3 criteria before it goes on to make an order.
Yes.
We know that the onus is on the applicant, and you've just shown us that the applicant has to put in the application the grounds upon which they say the convention is engaged. Now, of course, there may be, in particular cases, issues which are expressly accepted to be common ground, as in this case, it was accepted. There was never any dispute. But there was, the father had rights of custody.
Yes.
But the mother did put in issue the remaining threshold criterion under Article 3, namely whether father had habitual residence. So it was an issue. It's not as if there was a pleading or answer from the mother saying, we accept that if habitual residence was established in September 2020, it remained established throughout and is still there in July 2021. And if you were in that position, it would be much easier to say, well, the judge doesn't have to decide anything about that because that's accepted. But the mother's case is, I don't accept that H was habitually resident in Germany at the relevant date. And that's how the judge summarises in paragraph 2 of the judgment. One of the things she has to decide is, was Article 3 engaged? Was the child's habitual residence in Germany at the time of the alleged wrongful retention? So she knows she has to decide that. It's not, it can't be said that's not something that's an issue. It is an issue.
Well,
and I think what we're really talking about is how much consideration does she need to give to that question in circumstances where only particular aspects of that question are argued and other aspects are not argued extensively or perhaps at all.
yes.
I think that's the question.
Just to address two things of the proposition that you just advanced. In relation to the mother's answer, because she went effectively within the answer, in the operative, what I submit is the operative part of it, from challenging whether the child had ever acquired habitual residence in Germany, moving then immediately on to the defences. In my submission, she really was skipping the second stage, because one only gets to the defences if there has been a wrongful removal or retention. So it might not have been phrased in the way that you put it, and I accept it would have been a lot clearer if it had been.
We wouldn't be having this argument.
We
The
wouldn't.
point of being clearly raised. No.
Indeed. But the way that she phrased it is to the same effect.
Yeah.
In relation to how the judge summarised the case, in my submission that has to be read against the background of the way that the mother advanced it.
Well, no, I understand that.
So paragraph 2, subparagraph 1 of the judgment does encompass the way that the mother put her case. It's just that the mother's case was not that Article 3 wasn't engaged because the child had become habitually resident in England, it was that it wasn't engaged because the child in fact was still habitually resident in Uganda or had no habitual residence.
And I don't think the mother ever said the child was still habitually resident in Uganda.
My lord, she did. I'm sorry if I missed this, but it is in, I think...
I thought the judgment said that the mother accepted that was no longer resident in Uganda.
My lord, it...
Or
The mother's
end of
position...
paragraph 57. The mother does not actively assert that H's habitual resident is retained in Uganda, a jurisdiction she no longer lives in and does not seek to return to, where she's fled the country as a refugee and is later granted asylum for reasons we all understand. It's not surprising. She's not asserting...
No, but, my lord, in the 17th of February order, which we looked at earlier,
Yes.
the mother's case was recited as being the child was wrongfully retained in Germany in May 2019 and therefore he remained habitually resident in Uganda until September 2020. So part of her case was then continued habitual residence in Uganda. That changed for the trial, and she was effectively asserting, and this, as I understand it, is why the judge, I'll give you while I find the paragraph, at paragraph 58 said, the courts have made it clear it's highly unusual for a child to have no habitual residence. Her case at that point was that the child wasn't habitually resident in Uganda, but hadn't become habitually resident in Germany either.
That leaves England then, doesn't it?
Well, no, my lord. The assertion that she was making was that the child wasn't habitually resident anywhere. It doesn't leave England. England is one of the options, but that wasn't the way the mother was advancing the case at the trial.
Well, she's saying it's not Germany. She accepts it can't be Uganda. And she said in her position statement at the skeleton that it's the UK. So the judge must have appreciated that the mother's case was necessarily that the child was habitually resident in the UK.
Well, I don't think that I would accept that the judge must have appreciated that. And that doesn't, in my submission, follow from the judgment or the closing submissions that were made to her.
I don't, in fairness to the judge, I think it was, I'm not convinced that it was clear what the mother's case was on habitual residence. Paragraph 48, where the judge is summarising the submissions, she says halfway through paragraph 48, it's page 54, in those circumstances where the mother continues to make repeated requests for X's return to Uganda, the court should be cautious about concluding X's habitual residence was in Germany at the time these proceedings started.
Yes.
I mean, it looks to me as though the mother's at that point seems to. Well, then of course we go to the last sentence where she says she submits the habitual residence is in England based on what she says is the agreement reached between the parties in September 2020.
Yes, but that comes back to the consent point. And I'm not sure, my lord, that this adds anything, but it is very well established now. That
yeah, well, my lord's absolutely right. At the end, as I'm sorry, Mr. Lau, you're right. At the end, her case was England, based on consent.
based on consent. But the consent case was rejected. And one only reaches consent if there's been a wrongful retention. Maybe it becomes circular.
It does.
But, my lord, that's,
Well,
I fear, that's where we're left.
Yeah, right, yeah. Okay, all right. Have we probably, I think we've probably, I mean, you can always argue these points forever, no doubt find no nuggets if we keep on
We might.
sifting the sands, but I wonder whether we've dealt with this.
I think we probably have. Can I, my lord, just skip through the grounds and then get to what I say disposal should be?
Yes.
When I say skip through, I'm just going to go through each one and say what I say about them in a sentence.
Good.
My lord,
I think the issue we've been focusing is the main issue.
I entirely agree, my lord. In relation to ground one, the judge is finding that the child became habitually resident in Germany by September 2020 can't be faulted, and actually I think has not been forcefully challenged today in any event. Ground two is what we've spent so much time discussing, and I won't address it any further. Ground three, I say that the judge...
I mean, just before you go away from ground one, I mean, the fact that ground one appears there is quite revealing, because it's not... I mean, that shows it... There's further evidence that the focus of the mother's case has been that.
Yes, indeed. It's the first challenge that
Yes.
she makes. Ground three, we say that the judge did make a finding as to when the retention took place. Ground four, that case was never advanced to the judge.
Sorry, ground one, ground two.
Ground two is what we've spent so much
Yes.
time dealing with. I didn't intend to say anything further about that
No.
unless you would like me to. Ground three, the judge did make a finding as to the date of retention.
Yes.
Ground four, that is an example of a case that was never advanced before the judge, and so she can't be criticised for not having dealt with it. That is something that didn't even appear by vague reference in the mother's case. And as a consequence of that, settlement as raised in ground 5 was never a consideration here.
Well, settlement's the Article 12 point, and that's
Yeah.
dependent upon the 12 months.
Indeed.
The Article 20 point, which is the human rights point, is a slightly different point. That's not dependent on the 12 months.
That's not dependent on the 12 months, but, my lord, and I've referred to this within our skeleton argument. In the case of G&G, which was the asylum case determined by the Supreme Court, I was going to say last year, but possibly it's 2 years ago now, both the Court of Appeal and the Supreme Court considered Article 13b and whether, in fact, Article 13b added anything, whether Article 20, added anything and could be advanced as a separate standalone defence when the arguments that could be run under it really appear and are dealt with under Article 13b, and held that it couldn't. Well, the submissions in relation to that appear in the skeleton argument at paragraph 18c.
Presumably there could be other articles of the Convention in extreme circumstances which could be relied on, which aren't Article 13b cases.
Well, it's possible to envisage some, and Mr. Gupta has placed into the authorities bundle the case of SP, which was one case, in fact, I think one of only 3 or so, where Article 20 has ever been found on unique facts relevant to that child's particular identity and the treatment that she would face in the country to which it was said would be returned.
And there's also the issue which picks up the issue we spent so much time debating as to whether the court is obliged to investigate an Article 20 case if it's never ventilated or referred to the word. I mean, it is true the court is a public body which has to comply with the Human Rights Act and give effect to convention rights.
Yes.
To what extent does it have to do so if they're not articulated?
Well, my lord, where a person raises a defence under Article 13b that encompasses, for example, the difficulties as an asylum seeker they might face if they leave the country in which they're seeking asylum and go somewhere else, issues about ability to engage in court proceedings or similar, then the court would, through the lens of Article 13b, be considering and giving full effect to their fundamental human rights. And that is the way. There is a very large now body of European Courts of Human Rights case law about the 1980 Hague Convention, and it is mostly, not inevitably, about whether the court has done enough to investigate allegations under Article 13b.
Yeah.
So, my lord, in my submission, Article 20 doesn't actually add anything, and in circumstances where the judge has dealt, in my submission, properly and appropriately with Article 13b, there isn't any independent or further obligation for her to investigate other avenues that might fall under Article 20.
The only authority on that is the SP case, is it?
Yes. Well, my lord, G&G in the Court of Appeal.
Yes, G&G says...
which shows the limitations of
yes.
it, and SP, which shows an example on very different facts to these, it has to be said, of a judge at first instance finding it to be established. My lord, I think, for whatever it's worth, which might be nothing, in the course of the investigations for G&G, it was discovered that there had been worldwide 4 or 5 Article 20 cases.
Thank you. So that deals with ground
5.
Okay, 6.
6, there was no obligation on the judge to order a Kafkas report in circumstances where child's objections wasn't pursued. Certainly it wasn't necessary to order one to investigate the Article 13b aspect of the mother's defence. And in any event, the mother, I won't go through all the documents on this because it'll take too long, unless you need me to, but the mother's Article 13b case changed very significantly from her statements where she was saying that she couldn't return to Germany, and so Article 13b would be engaged because of a possible separation, to the trial where she accepted that she would. So in those circumstances, there certainly isn't.
Case management decision.
Yes, and nobody asked her, anyway, for a Kafkas report.
No.
And the time to ask would be, as we saw from the practice direction, when you give those directions. One of the directions you can give is what steps should be taken to obtain the child's views.
It's something that should be considered at the first hearing, and in this case, it was, because the order shows a recital that the mother expressly did not rely on child's objections.
What are child's objections? Is this a technical...
It's
The 13.
Yes.
Hence it's 13.
It's a separate limb of the Article 13 defences that doesn't have a letter affixed to it. So it is sometimes referred to as Article 13.2. And
If you look at
Look at the text of 13.
the text.
yes,
Physical or psychological harm will place the child in an intolerable situation, or if the child objects to being returned. So this was not a child's objection case.
no, the mother never pleaded child's objections as a reason as to why the child should
And
be
if you
returned.
do have a pleaded case of child's objections, then is it the practice to get a Kafkas report if the child is of sufficient age?
Yes. The obligation under Article 13.2 is to take account of the child's views subject to their age and degree of understanding. So it is unusual and probably unheard of for a 4-year-old to be spoken to for obvious reasons. If you have a 13-year-old, in almost every case, they will be spoken to by a counsellor.
7 or 8
Well-
on the cusp?
It's got younger over the years, is that right?
Yes, it has got younger over the years. I would submit, Mr. Gupta may disagree with me, a 7-year-old is very much borderline as to whether there would automatically be a report. Because, of course, one always has to balance when considering this, the benefit of obtaining the evidence as against the impact on the child of doing so. And however,
Presumably the Kafkas officers are specialist and experienced in talking to young children.
they are.
They are.
They are very much so. But however much it is made as comfortable a process as possible, if in fact because of the child's age it's likely to lead to little or nothing,
Yes.
that would be a reason as to not having a report in a particular case. I have never, I think, for whatever it's worth, I don't think I've ever had a case where a Kafkas report has been commissioned purely to investigate Article 13b. There may be examples, but
Well, there may be arguments for expanding the scope of Kafka's inquiries, but I don't think that's an issue which is going to feature in our judgments.
no.
On this
What
occasion.
about separate representation? In what circumstances is it common for a child to be separately represented?
It is quite common but not inevitable where settlement is engaged. There is an entire practice direction about the separate representation of children, which includes within it a series of factors that the court takes into account when deciding whether separate representation is required or not, the leading of which is whether it's in the interests of the child for them to be represented. Usually it is appropriate if separate representation would assist the court in its understanding of whatever the defence is that is being raised in a way that other methods would not. So sometimes, for example, a Kafkas report can't provide as much of an illumination of a child's position as them being separately represented and the guardian, if there is a guardian, advancing the child's case through their own lawyer would. But it's a balancing exercise. It is something that happens more frequently now, but it is still relatively, unusual would be the wrong word, but most cases under the Hague Convention, the child is not separately represented.
Older children usually.
Older children sometimes are. There is usually, not automatically, but usually a Kafkas report first, and the Kafkas officer often will make a recommendation as to whether in their view it's in the child's interest to be represented or not, but that isn't automatically so. And that leaves only, I think, Articles 7 and 8.
Section, grounds, section.
Grounds,
Yes.
Grounds 7 and 8.
Well, you've dealt with that 13b issues in your document.
I certainly have.
What about the suggestion that whatever the judge thought, your client's subsequent behaviour shows that he is not to be trusted in his undertakings?
Well, my lord, there are two ways of addressing that. The first is that on the basis of the English understanding of the law, a case called Re Y, which is within the authorities bundle at tab 11, undertakings given in the course of Hague Convention proceedings are considered to be measures for the purposes of the 1996 Hague Convention, which are then recognised by operation of law and can be enforced in the country of return if that country is also a contracting state to the the 1996 Hague Convention, which Germany is. So there is a means by which the undertakings that the father has given can be enforced in Germany by that mechanism. But if there is a further argument about that, in my submission, the appropriate venue for that is before the trial judge in the course of consideration of either implementation of the order, if that was the situation we were in, or, as was discussed at the end of Mr Gupta's submissions, in the context of an application made by the mother or on behalf of the mother to set aside the order on the basis that the father has shown himself not to be good, as it were, for the undertakings that he's given.
Does that lead to a submission? There's nothing we could do about it, however disturbed we might be by the father's apparent willingness to ignore what the court has accepted from him by way of undertaking. I mean, there can be no doubt, can there, that the undertakings, which are intended to provide a practical mechanism whereby the child can be returned to Germany without significant adverse impact on him, by enabling the mother to go too, are a significant factor in deciding the case in which way which was decided. So if the premise is falsified because the undertakings are not worth anything, then does that not undermine the order?
Well, my lord, it might. I'm going to deal with this as a hypothetical, if I may, but it might be a significant change of circumstances that justifies the judge in revisiting her conclusion. But that would be what I'll...
Suppose we thought it was a significant change of circumstances. Would it just... And we have all the powers of a lower court. Would it justify us in revisiting the order?
Well, this feeds into some of the submissions I was going to make about disposal. But
yes.
That is not a straightforward issue in the situation in which we now find ourselves for various reasons. If you...
Well, on the face of it, subject to anything you want to say, there's been a plain breach of the order, of the undertakings by your client.
Yes.
Paragraph 65 is where the judge deals with the 13B defence, and part of her reasoning for dismissing it is based on the father's undertakings.
Yes.
So, if we ask ourselves the question, is this a significant development that changes the landscape from that which the judge thought she was dealing with, one would have thought that the answer to that was fairly obvious, that it is a significant development, and one which is potentially one which impacts on the appropriateness of her order. And we might not be in a position to decide what is appropriate in the circumstances, but we might be in a position to decide that, given what's happened, it should be looked at again.
My lord, if my lords dismiss the appeal, child is habitually resident in Germany, or was at the material time, and is now in Germany. The German courts, for the reasons that I gave at the beginning of my submissions, have jurisdiction in relation to that child if Mrs Justice Theis' findings are upheld. In those circumstances, even if you were to conclude that the landscape has shifted so much in relation to the Article 13B defence that her conclusions need to be revisited by yourselves or by a judge in the lower court, in fact, there wouldn't really be anything that the English court could do, because the child is in Germany and is habitually resident there on that analysis of the case. If you allow the appeal in relation to her conclusion about habitual residence, then the question of jurisdiction is undetermined.
Is undetermined, I see the point.
And in my submission, and that's the paragraph that we've all, that you collectively have raised.
So that's remitted for determination.
Yes.
Yes, if we allow the appeal on that basis, then we're into your alternative submission at the end.
And this point could be, and then everything's at large again.
Yes.
Including the 13B point.
Well, you'd first have to decide which court has jurisdiction, and then it's for that court, whether it's here or there, to make the
Yes.
I think, following on, what if we don't, if we're not persuaded by Mr. Gupta on his principal arguments about habitual residence, could we still set aside the judge's order on the grounds that the basis upon which 13B, the 13B's offence was dismissed, have been invalidated or undermined by the subsequent events, and direct that it be reconsidered?
Theoretically, my lords, you could, but the substantive conclusion that this child is habitually resident in Germany would then stand.
And the German court would have jurisdiction.
The German court would have jurisdiction, and The Hague would be at an end.
So the critical question, in practical terms, is whether the judge's conclusion on habitual residence stands or not.
Yes.
If it doesn't stand, then all bets are off, and you start again.
Well,
up to a point. But if it does stand, you say whatever else happens, it's for the German courts to take forward.
yes.
And what do we do? Do we do anything about the fact that, as I've just reminded myself, your client appears on the face of it not only to be in breach of the undertakings he gave to Mrs Justice Theis, but in breach of the peremptory orders made by Mrs Justice Russell?
On that analysis, the orders made by Miss Justice Russell would have been made without jurisdiction, one way or the other, in my submission. If the child wasn't habitually resident here, wasn't present here, was habitually resident in Germany, there is no power in that context, I would submit, for the court to make orders about the child.
Make orders against your client as a party to proceedings.
That might depend on what type of orders. If the order against him was to bring the child back to England, I would not accept that at all, because that is in fact an order about the child. It's a matter of parental responsibility, which falls within the jurisdictional scheme, which all points to the German courts having power.
Well, I won't conceal my view that there is something deeply unattractive about someone who is told not to take a child out of the country and promptly doing it. It's not told by their advisors or told by other people. It's ordered by a court and has given a promise to the court not to do it, and promptly goes and does it. It's not an attractive position for you to seek to defend.
My lord, all that I'm seeking to do through the submissions that I have just made is to set out for the court what, on my submission at least, the jurisdictional framework is. Of course, I have to make submissions about that if, on my case and my analysis, the alternative would be the court making orders that, under the relevant jurisdictional scheme, which is the 1996 Hague Convention in this particular context, it doesn't have power to make.
What's the submission? What you seem to be saying is if this court, in the course of proceedings such as this, makes orders that a party does not take the child back to another jurisdiction, those orders are written water.
Well, only, my lord, if there is a jurisdictional issue in relation to the court's power to make them. If there wasn't an issue about where this child was habitually resident, and there was a clear jurisdiction here, of course I wouldn't be saying what I'm now saying to the court. But that isn't where we are.
Well, never mind in a sense, never mind these important points about court orders, which my lords emphasise, and I endorse. There's also the question of the impact upon this small child who's been removed from his mother without her consent. And I, for my part, am extremely concerned about what the likely impact will be on him as a result of that. And I know your client is watching, at least I hope he's still watching, and I hope that he will reflect very carefully on the impact of his conduct on the child. Because sooner or later, a judge will want to consider that.
Yeah.
Can I just pick up your point about if there isn't any jurisdiction, there isn't any jurisdiction? I will readily admit I'm not familiar with the particular rules in this context, but in other contexts, if there's a dispute as to whether a court has jurisdiction, it can grant protective measures in the interim until that dispute is resolved. What happened here was, although the judge decided in favour of the client, habitual residence in Germany, there was an appeal. Permission was granted to appeal, and the effect of the appeal was that a stay was granted on that order. So that, in a sense, the question of jurisdiction is still unresolved, and it remains unresolved until we've handed down our judgments. And while it's unresolved, does the English court not have power to grant protective provisions in the interim?
Well, forgive me if I expressed myself in a way that was unclear. The answers that I gave were on the contingent basis either that my lords granted the appeal or if my lords dismissed it, and primarily in relation to the dismissal of the appeal. I accept entirely that while proceedings are ongoing, courts can make interim orders, including protective orders. There is a potential difficulty in relation to the reach of those orders, primarily because there is a recognition and enforcement scheme as between England and Germany, and one of the key parts of that is that if orders are going to be made by the English courts and then recognised and enforced in Germany, they have to be made on one of the bases of jurisdiction available under the 1996 Hague Convention. And those bases in this context are habitual residence. I mean, this is a bare summary, but habitual residence or presence. And so if orders are made in the current circumstances, where the child may or may not be habitually resident here, that's an issue to be determined if you allow the appeal and the child isn't present here. Whilst those orders might have effect within the jurisdiction of this court, they wouldn't have an international reach.
It could not be reciprocally enforced.
No.
Obviously, the orders of this court and the fact that your client has flagrantly broken the orders of course, this jurisdiction, are matters which the court in any other jurisdiction would take into account.
Yes.
And I think you said that, I mean, that applies to the order made by Mrs Justice Russell, by which stage the jurisdiction could not be based on presence. But the undertakings given to Mrs Justice Theis were given at a stage when the child was present in the jurisdiction, and you said they were measures which could be given effect to by the German court.
Yes, but within the confines of what those measures are. So an undertaking that the father won't remove a child from another parent could be enforced in those terms upon a return if the German court deals with it as the Court of Appeal says in Re Y. But that is not necessarily the same as an order that the child must be brought back to England.
No, understood.
Is there anything else you want to say on consequential orders?
My lord, the purpose of the alternative proposition that we advanced in the skeleton was really to reflect the fact that there are findings that the judge made that aren't challenged at all in the appeal or which can't reasonably be challenged. So if there were a remittal of the case to Mrs Justice Theis or another judge to deal with the jurisdictional issue, findings that would, in my submission, be upheld in any event are that the child was habitually resident in Germany by September 2020, and that an agreement had been reached between the parents for a temporary stay in this jurisdiction on the basis that the judge found just to root it in the judgment.
What you're really saying,
62.
you're really saying is if it's remitted, you don't want everything to be open to be re-argued. You want it to be a very limited remittal of specific issues.
Could that be remitted to Mrs Justice Theis?
Well, Lord, in my submission it could be. Mr Gupta may differ from me on that. But if your conclusion is that in fact what happened here was that she dealt with the case broadly as it was presented to her, and that through no fault of her own, which in fact is Mr Gupta's submission, there were parts of that that were not raised in front of her, and she's blameless therefore in not having dealt with it, she has obvious advantages in terms of dealing with this case than a judge coming at it afresh.
I mean, really, there's our point would be, if we go down this line, that there's a lacuna in her reasoning, because she doesn't consider the integration evidence, such as it was, or not, or such as it wasn't, perhaps,
Yes.
such as it was, between September and July. And for her to make a decision about habitual residence in July, she needs to consider that evidence. That being about that.
If that was your conclusion.
Okay, and you say that could be fairly dealt with by Mrs Justice Theis.
Yes.
And there may be other reasons why it would be appropriate for the same judge to remain seized of the case.
Well, if there's an
Subsequent.
element of set aside because of
Yes.
subsequent events, the approach to that is that if at all possible, it should go back to the judge who made the original
Yes.
decision, for reasons that are obvious.
Okay.
The, considering whether there was habitual residence in Germany as of July 21, as opposed to England, would require a looking at the whole of the evidence and arguments in relation to residence in Germany. You couldn't just, as it were, start as of September 2020. You'd have to look at that evidence again. And I think it would be unfortunate to start that analysis with an assumption as to the position in September 2020.
Well, Lord, in my submission, not. The judge weighed up the evidence, and her judgment is rather fuller in relation to this, as I've
Yeah,
accepted.
but there'd have to be new evidence,
Well,
wouldn't there?
well,
Well, not in my submission in relation to that period. The father presented evidence as to the nature of the child's life, the events that he was doing, the family structure that he was within in that period. And that provides a baseline in my submission as to what the position was as in September. What the court would need to look at if Mrs Justice Theis didn't do this is whether the child thereafter acquired some degree of integration here. But that can be done against that background.
Well,
if we look at the grounds, what I'm postulating, and it's, we're throwing things at different angles for me, I know. I'm postulating that the appeal on ground 1 is dismissed on the grounds that the judge was not in law, in fact, to find that the HR was in Germany by September 20, but allowing the appeal on ground 2, in that she felt she was wrong and she failed to take into account the integration in England from September onwards and whether the child had become habitually resident in England. So that's what I'm suggesting. We're all suggesting something slightly different.
Yeah.
I'm not sure.
I don't think I'm suggesting anything. I'm not suggesting anything.
My Lord, Lord Nugee is keeping his powder.
I'm not currently suggesting anything, but I'm interested in what might be the possible outcomes.
Yeah, I mean, yes, I'm not saying which way we're going to go, but those are the options we're postulating.
I understand that, and my lord, if you're against me on my substantive case, then those are two of the options. But my submission is that in circumstances where there really isn't any reason, in my submission, to overturn Mrs Justice Theis' decision on ground 1, there is no harm to the subsequent inquiry in taking that as a baseline proposition, that there was habitual residence
Well, I
in
understand
Germany.
that, but if we're applying a seesaw approach, and you're going to be looking at one end of the seesaw, what happened from September 2020 in England, but when working out where the seesaw ends up, you have to know not just that there is weight on the other end of the seesaw, but exactly how much weight there is. And you're going to have to, you can't simply now look at the residence in England. You're going to have to compare it and see how it affects the residence in Germany.
I mean, Lord's right about that, isn't
Yes.
it? Because
So you can't,
even if ground 1 is dismissed on the grounds the child was habitually resident in Germany, as Maud says, that so what in a sense that it's the degree of integration in Germany is still relevant.
You still have to look at, you still have to take it into account.
Yes.
And the problem is that if the mother and father both give evidence again on that issue, restricting them to only looking at the position in England post September 20 would be quite difficult.
Maybe there's a difference. I don't think it's necessarily even a difference between us, but it might be. In terms of maintaining the finding, and in my submission, there's the difficulty that my lord is describing doesn't arise through maintaining the finding that there was habitual residence in Germany in September 2020. I wasn't suggesting at all, forgive me if it seemed as though I was, that when considering the next question, if that's what's to happen, the judge can't look at the quality of the habitual residence that the child had in Germany at that stage in order to judge what weight was on the German end of the gigantic seesaw. Presumably had to pivot somewhere in front.
Then you're going to be hearing evidence about the position in Germany, but the judge's hands will be tied as to the conclusion with regard to that.
I think the judge's hands would be tied as to the finding that there was habitual residence in Germany.
Yes.
But that wouldn't prevent the judge from considering that as against the connections, if any, that the child subsequently acquired
But the evidence
in
may
England.
be different.
My lord, it would.
Yeah, well, I think this is, we'll have to, anyway, if we get that far, we'll have to consider that. Any other points on consequential orders?
Forgive me for.
Mr. Papazian wants to ask.
Can I turn my back?
Give you some instructions.
The point that Papazian makes to me, and which I make to the court, is that perhaps perhaps the proposition that is being advanced rather supports the case returning to Mrs Justice Theis, because she is far better placed, in fact, having reached the determination as to habitual residence in September 2020, to decide what weight that has in the balancing exercise when comparing it with any conclusions she reaches about connections the child subsequently acquired in England. My lords, beyond that, there isn't anything else I wanted to say about disposal.
Or anything else?
Or anything else, unless there's anything you'd ask of me. I'm sorry I went so much over the time I said.
No, well, it's because we were debating with you, Mr. Gratian. Thank you very much.
Very good.
Gupta.
Very briefly, as far as possible in reply, just on that latter point, we wouldn't oppose at all the matter being remitted before Mrs Justice Theis if that was the court's decision. First point with regards to evidence that the mother provided for her with regards to habitual residence. These have been touched on already, but just for your lordship's notes, of course, we've got the mother's, that's the appellant supplementary bundle, which has her statements within it. Page 51, paragraph 21. Hines has resided in the UK now for over 15 months.
Will you don't say the child's name, please.
I beg your pardon. H has been residing in the UK now for over 15 months and is habitually resident in the UK. Therefore, I ask the court to deal with this case here. Next page reference is 209, which is paragraph 21. H has now been in my care since September 30th, 2020. I'm his primary carer. He's happy, settled with me in this jurisdiction. And then further reference at page 234, paragraph 22, which I know your Lordship, Lord Justice Phillips referred to. Paragraph 22, H has now integrated within this jurisdiction. He has been in the UK since September 2020, etc. That's dated 25th of February 2022. Now, integrated is a loaded word. It's not used in Hague Convention proceedings without a reference to habitual residence, because some degree of integration is the very definition.
In the social and family environment.
Indeed. Yeah. And so to say that, unfortunately, of course, it's couched under paragraph 21, which refers to Article 13b, but these references in the evidence were not dealt with great respect by the learned judge at all when she looked, as as you lordships pointed out, at paragraph 60 in her judgment. And I've asked my learned junior whether or not they were dealt with by the father in his evidence in response. I don't believe that there was anything from the father about child's habitual residence in England between September 2020 and July 2021. So that's a lacuna, one could see it that way. That is, the judgment is of course unclear, especially when you compare it to the order, the recital in the order. But if your lordships were to turn to paragraph 23 of our respectful written submissions, that's page 10 of 17, page 380 of the court bundle. We touched on this burden of proof point, and Lord Justice Nugee's point about the application crossing the threshold criteria, effectively. And of course, hardly any case actually swivels on the point of burden of proof, but in our submission, it was for the father to prove German habitual residence, if gained, had not been lost by July 2021, which is when he said the retention began. The mother doesn't have to prove English habitual residence, but it's a logical consequence of what she is saying. And the point that we like to remind the court of is that word comparison. Towards the end of that paragraph, it's more than likely, but no detailed comparison is evident from the judgment of the court below. In other words, the way the learned judge looked at German habitual residence in September 2020, if you compare that to the way she looked at English habitual residence in July, question of it in July 2021, is not, with great respect to the learned trial judge, apparent from paragraph 60, from those few words where she says, was in Germany and remained so. She didn't refer to the evidence and didn't go through it in any shape or form, and so consequently, that's why we respect that the appeal should be allowed. The question is whether she gave any consideration, or some consideration. We say none, really, in reality, with great respect to her. But the question is whether or not, if one looks at the grounds, picking up from what the lordships were just discussing earlier on, whether the court's hands, if the court does remit this to the court, whether the court should bind the learned trial judge's hands by saying, well, you were correct in ground one, that's to say, appeal dismissed on ground one, habitual residence in Germany is allowed for, it is correct, but you're going to only look at the position from then onwards in England. From our submission, the learned judge should be allowed the practical step of being able to look at the case in the round, to look at the degree of integration, because that is important. And if it's of any assistance, tab 3 in the authorities bundle is the authority of REM, Habitual Residence 1988 Convention, which is the Court of Appeal decision, Lord Justice Moylan, paragraph 61 through to 69 provide the court with...
Which tab?
Tab 3, where he refers to Mr Justice Hayden's summary at the bottom of paragraph 63, page 11 of that tab 3, page 135 of the actual authority. But if you look at the top of page 136, that's to say paragraph 63, the court, from the essential task of analysing the situation of the child at the date relevant for the purposes of establishing jurisdiction, or as in the present case, whether retention was wrongful. And that's the analysis that we respectfully submit is lacking, with great respect in the judge's decision. The points of retention, what was the child's habitual residence? And it's a question that the learned judge, unfortunately, needed to ask herself, because it wasn't really put fair and squarely in front of her in the submissions. But when it comes to an application, the question is, in any civil case, of course, does the application get off the ground? Does it have those essential ingredients? And one of them would be habitual residence at the relevant date. And having been having looked at the relevant date, where she doesn't actually set it out, that unfortunately started the difficulty when it comes to not looking, as she did with looking at the habitual residence at the appropriate period, which is, we would say, July 2021. Does the court have a duty for greater judicial scrutiny when it comes to the application? No, we would say, as I just said a moment ago, no more so than any normal civil application, where a learned judge, trial judge, will be thinking, well, first and foremost, does this application get off the ground? The onus is on the applicant to provide evidence of the essential ingredients of that application. And the father didn't provide, it seems, any counter evidence to the mother's evidence of English habitual residence at the time. Even though it's not much evidence, she did provide, we would respectfully submit, enough time, presence, schooling, home with his mother.
Are you abandoning any suggestion that there may be a superadded need to consider the interests of the child?
No, I'm not. I'm not abandoning that, but I have to say it's couched in it's not a broad approach from my submission. These are Hague Convention proceedings. I don't know how the court would phrase it, but we say that the court needs to have a weather eye on the unrepresented.
Doesn't the preamble to the convention help you?
Yes, indeed it does. Because it refers to the best interests.
It says the
harmful
interests of children are paramount importance.
Yes.
And desiring to protect children from the harmful effects of their wrongful removal. Establish procedures to ensure prompt return to the state of their habitual residence.
Yes.
So if a judge were to return a child to a state which was not their state of habitual residence, simply because a party hadn't argued the case properly, then arguably they would not be fulfilling looking at the interests of the children as paramount importance. Indeed,
and that's, with great respect, I'll adopt that, pray that in aid of the court's slightly different obligation when it comes to Hague Convention cases, 1980 Hague Convention cases. Just two further points. This child has now been abducted twice by his father. Once as found by Mrs Justice Theis in the court below, she found the father had wrongfully retained the child. And secondly, it's a fact. He removed this child unilaterally in breach of his undertaking to this court without the mother's permission. That is an abduction. The question is it a wrongful removal? Is the child habitually resident in this country? And the best person to analyse that is, we would respectfully submit, the trial judge in this matter in the court below, and to be able to look at the breach of undertaking and for her to, very experienced judge, to be able to say, well, that is not a defining factor in my decision when I decided this child should go to Germany. The father's actions have effectively counted against him in that respect, because that militates towards the matter being restored for the court below to determine the matter, and we respectfully submit that this court should set aside the learned judge's decision, allow the appeal, and allow Mrs Justice Theis to have a look at the matter afresh. Last point is about court's jurisdiction on interim decisions. We respectfully submit that those decisions by Ms Justice Russell and Ms Justice Judd.
Well, I don't think Ms Justice Judd did anything except.
Sorry?
Mrs Justice Judd did nothing except.
Absolutely, yes.
She did nothing.
She
just said the orders remain in force.
Yes, indeed. I'm grateful for that. I touched on this earlier on before the short adjournment. Interim powers. Now, if the court, in your research, looks at page 367 of the latest Red Book, it's got section 5 of the Child Abduction and Custody Act, which are the interim powers when the court is looking at a child abduction case under the 1980 Hague.
What's your point on this then?
Well, the note says as follows: extent of the court's power on interim direction. The court has very wide powers to deal with all interlocutory matters including taking all appropriate steps to ascertain the whereabouts of the child, ... the court can exercise jurisdiction even before the child's arrival within England and Wales. So the child's physical presence is in the country is not a prerequisite for the court to exercise interim powers under the Child Abduction Custody Act. So this must have happened before a child has been removed during the course of Hague Convention proceedings unilaterally by the applicant. I can't refer to any particular case, but there are the interim powers.
Thank you very much.
Grateful, thank you.
Right, well, we're very grateful to all counsel, leaders and juniors, for their assistance in this case, and your instructing solicitors. I've said enough about the state of the bundles. I don't need to repeat that. We're going to reserve judgment in this case. That means that the judgment will be handed down in the usual way. It will come out to you first in draft for correction of typographical or minor factual errors. I draw your attention to the rubric at the top of the draft judgment, which prevents, by order of the court, any wider publication, which would be a contempt of court. You'll be aware of recent cases in which draft judgments have been disclosed and of the words of the Master of the Rolls, warning of the consequences if that were to happen again. I would not want that to happen in this case. When we've had your comments back, we will hand down the judgment. We'd be grateful if you would agree in terms of an order in the light of our judgment. Any matters that aren't agreed will be resolved in writing. Thank you very much.
Thank you.